Testing 1 2. Testing 1 2. Testing. Testing 1 2. All right, people, what's up? Welcome to the Supreme Decisions Legal Minute Podcast, and I'm your host, Supreme Decisions. As you can see on the screen, yes, we are getting ready to talk about. A brand new case that we can use in our legal defense strategy, and that's Barnes v. Felix, and it was decided in May of this year, 2025. So, we're diving into the background of this groundbreaking Supreme Court case that affects police shootings, civil rights, and how criminal defense can be set up or mount their cases on this case itself. Barnes v. Felix was decided May 15, 2025, and it has big implications for anyone concerned about police use of force and those on the other side, including the defense of accused, which is yourself in some cases. Now, I want you to understand context, because there are many grounds for police use of force. Because if you're watching my shorts, or if you're watching my TikToks, or you're watching even my Instagram Reels now, I put up a police officer flashing their flashlight in your eyes or in your cameras. That is under the guidelines of use of force. This is one of those things which this case takes effects, because it talks about or deals with the force and the police escalating at any point prior to using any actual physical force. Because even if it's on the eyes, it causes damage, because it literally says on the flashlight, do not shine in human eyes. It says on the flashlight. It's not even, it's standard issued on the flashlight. So when we're talking about that, this is what we're getting ready to get into. So imagine this scenario. It's a routine traffic stop on a Houston highway. The driver, Ashton Barnes, is pulled over for an unpaid toll. I'm going to say that one more time. Wasn't something crazy. Pulled over for an unpaid toll. Nothing violent. Barnes is simply a young black man in a rental car without his license. Didn't say he doesn't have one, saying he doesn't have them with him. Then things escalate far beyond a typical traffic stop. The driver tries to pull away, and in response, the deputy constable leaps onto the car and shoots into the windshield. 5 seconds later, Barnes is dead. The officer survives unharmed. Now, this is also where Tennessee v. Gardner comes in, because one of the guidelines for Tennessee v. Gardner is there has to be something else used to cause harm other than the vehicle. An officer is not allowed to shoot into a moving vehicle if there is no other aspect of harm that can be caused except for with the vehicle. So there was a video, I wish I had downloaded it, where it was a young man, and I spoke about this a couple years ago. He actually was pulled over down the street from his house. He was fixing on the truck. He drove down the street, went and got something to eat. He was pulled over by a police officer that knew him. So she goes, well, hey, I'm going to check and make sure your license is valid. I'm going to give you a ticket for that. He goes, all right, fine. She said, go ahead and finish eating your food. Y'all going home, because he lived literally right down the street. They were cool. So while she's in the car doing what she needs to do to set up for the ticket, because she's already stopped and she's already called it in, her partner goes over and begins to escalate. So you could tell the moment that they had made a decision, because the passenger had stopped eating his food. Because you can't, what the officer is saying on either body cam, you can't hear. You can't understand it. But he says something to where the driver looks at him funny and the passenger stops eating. Again, he lied about what was said. But what happened was, when the passenger stopped eating, he leaned back in the seat. He wrapped his hamburger up. The driver punches it. Well, as soon as he does that, the cop then jumps onto the vehicle, shoots inside the cab. He nicks the passenger, kills the driver. In his report, he said they attempted to not flee, but attempted to run him over, and they placed him in danger. When, one, he's on the side. Two, he never turned to go into a ditch. He actually turned away from the officer. So when the officer jumped on the car, or on the vehicle, he then placed himself into danger. Now, a lot of people argue with me on it. It was funny because I went back, I want to say a couple weeks later, and I posted that officer that had jumped onto the vehicle lost his post certifications in Tennessee. Why? Because he placed himself in danger and then he lied in his police report. And at the time, the only way to make that go away was to get rid of him and to just let the story die out and let people speculate, which that's what they did. Now, I don't know if this officer was working again. My dumb ass at the time did not get his name. But it also goes back to this Barnes case, because the officer placed himself in danger and he did something that is outside the guidelines of not only training, but is outside the guidelines of physical force use and constitutional safeguards. So today I'm going to explain how Barnes' mom brought a lawsuit under the Fourth Amendment, how the lower courts initially sided with the officer by focusing only on the final 2 seconds, and how the Supreme Court swept the approach away in a unanimous decision. We'll talk about the court insisted on looking at everything that happened before the shooting, from the moment Barnes got pulled over to those fatal last seconds, and what that means for defending yourself in criminal cases. Now, we're going to break down the key legal principles. We'll make the Fourth Amendment easy to understand, because that's what we do, and give you real-world context with other cases and explore how yourself can use Barnes v. Felix in the courtroom. By the end, you'll understand not just the facts of Barnes' strategy, but how its ruling shifts the way courts view police shootings. Now, stick around, because we'll also share real examples, just like I did with the Tennessee v. Gardner, in recent incidents, even like the Philando Castile case, to show how this totality of circumstances rule can change the narrative. Whether you're a criminal defense attorney, a law student, someone that's just been charged with a crime, or a concerned citizen that just likes the law, we're going to talk about it. We're going to give you an understanding. So let's get started. Now, I'm going to give you something too. I'm going to give you something that's going to set a precedent. And then I'm also give you something else. Philando Castile case was one that I went on and I said a lot of crazy things about. Now, the reason why I said crazy, because at the time, I did not give any context. I spoke about how Officer Geronimo illustrated the level of cowardice that should never put on a police uniform. I did do that. I never gave any context behind that. Now, if you're not familiar with Philando Castile was pulled over. He had his wife and child in the car. The child was seated in a car seat directly behind Philando. The wife was on Facebook Live soon as she turns on Facebook Live, soon as they get pulled over. In the midst of this citation, because he's going to get a ticket for speeding, Geronimo is the initial officer. His partner pulls up in the flanking position. Castile tells him he's complying, as they like to use. And he then tells the officer, yes, I have a registered firearm. It's on my right hip. Geronimo says, don't reach for the gun. Get me your license. So he puts his hands up and he turns. Hands are still up. Geronimo shoots him twice. One of the bullets go through Philando Castile into the back seat where the child was. Now, here's the important part of where the context comes in at. Police officer was told there was a gun. The police officer gave instructions that were followed. The police officer then panicked when there was no reason to panic. How do I know that? Although he was found not guilty, Geronimo's partner asked him, you can hear it on the body cam. He asked, why did you shoot him? He was doing what you asked him to do. Now, Philando Castile's wife instantly reached into the back seat, grabs the child, and the officer begins to scream. Geronimo is still holding his gun, shaking and screaming. He tells her to be calm. Her state of mind was, yes, sir. I will remain calm. While her husband lays bleeding out in front of her. While the bullets almost killed her child, she is more calm than the trained officer. She was also put into a position to where she was afraid to hold him liable. Because we know most cases, prosecutors cherry pick cases and piranha don't eat piranha. So him not being convicted was not a surprise, but him not being tried for wrongful death due to his negligence, because fear is a form of negligence, because he acted outside the guidelines of his duties. Now, I'm throwing it out there because I'm setting something up, because I hear this more often than not. Because everybody always asks me, well, what's the statute of limitations? And I've literally posted it. Matter of fact, it's on this page. I want to say it's posted on this page 3 times. There's actually a story, or what do you call that? A short, with just the statute of limitations listed from the federal government website with the address of it. People still ask, well, that's not right. Even though you asked the question, you asked for source, it is shown there. It is a literal screenshot. And people say, well, it's only 2 years. And I've given it to you verbally. I've given it to you in writing. I've given it to you through actual video. Now, I'm going to set the stage with these facts. On April 28th, 2016, Deputy Constable Roberto Felix of Harris County, because you know they're my favorite people, because they're the easy target right now, got an alert about a car with unpaid tolls. He spotted the Toyota Corolla, turned on his lights, and pulled it over on the Beltway. Ashton Barnes, the driver, explained he did not have his license. The car was a rental in his girlfriend's name, and began searching inside the vehicle. Felix smelled marijuana and asked about it. All normal so far. I'm gonna go back to something. Take a little bit of this Red Bull. Just in case you're wondering. Hold on. There we go. Green edition. Actually tastes pretty good. Caruba and elderberry. I recommend it. It's actually pretty light. Got a nice sweetness to it. Not too harsh on. But see, again, Red Bull ain't paying me, so we're gonna move on. But I'm gonna read this date off again. April 28, 2016. April 28, 2016. I originally stated that Barnes' mother is suing for wrongful death. This case, where we at? Bang. Was decided May 15th, 2025. More than 9 years has passed. So, according to these people that tell me that all the stuff that I posted is wrong, and the federal government is wrong, that 2 years of statute of limitation is way past. But we got a Supreme Court decision, and we still have a lawsuit for wrongful death. So this is why I tell people, I don't just say stuff to be talking. This is real life right now. April 28, 2016, the Supreme Court case decided 9 years later, on May 15, 2025, and the wrongful death lawsuit is still going 9 years later. So that 2 years is BS. Now, let me go back into it. Because as is normal thus far, things then escalate. Felix smelled possible drugs and asked Barnes to exit the car. Now, 2016, they got away with using, I smell marijuana. That is no longer the case. They can't say, I smell anything without your consent or a warrant or plain view. They can't search. So, let's keep that going. Barnes opened the door, and instead of getting out, he turned the car back on and started to pull away. In response, Felix unholstered his pistol and jumped onto the car door while it was moving. He yelled, "Don't effing move," and without any clear view inside, fired 2 shots. So he's just randomly shooting. One of the bullets kills Barnes almost instantly. Barnes managed to stop the car before collapsing. Remarkably, only about 5 seconds passed when the car first moved and when it stopped. I want to give you a context of 5 seconds. You ready? Go. That is the time it took for the car to start and stop. Just let that sink in. In that amount of time, someone lost their life due to a police escalation that was unnecessary and now unlawful. And just 2 seconds between the deputy jumping on the car and him firing his gun. So basically, as soon as he jumps on, and he was busting shots blindly, and he wasn't Tupac. He wasn't trying to find Jehovah. He was doing something out of fear and attempting to be something he's not allowed to be, which is a hero. He was trying to be super cop. And here's the craziest part about it. This chilling dashboard moment shows how fast a routine stop can turn deadly. The grand jury later cleared the officer in criminal court. Because remember, ready? Piranha don't eat piranha. Because if there was a true wanting of an indictment, the prosecution would have gotten one. Give you an example. It took them 4 times to get a true bill on me. They then proceeded to indict me, I want to say, me and my brothers, 7 more times coming during the trial. We were indicted 7 times. It took 4 times for them to get one true bill. Then, after they got that one true bill, they got 7 more matching indictments. Why? Because they can indict anything and anyone they want. It's just something else that you can challenge. That's it. It means nothing. But the simple fact that they're cherry picking who and how they indict is the problem. That is why you challenge everything. And even in this, the officer argued reasonable fear for his life as the car drove off with him hanging on. Now keep in mind, he placed himself onto the car. He put his life in danger. He created the fear that he believed allowed him to take someone's life. Let that sink in. Now, Janice Barnes filed a civil lawsuit claiming the shooting was excessive in the violation of her son's Fourth Amendment rights. In federal court, this case faced an uphill battle. The district court and the Fifth Circuit, what was known as the moment of threat doctrine, is now gone. The moment of threat doctrine is null and void. Right? Because at the moment the officer pulled the trigger, he could have reason to believe his life was in danger. Why? Because he placed himself in that position. Not that he was in an actual danger. He was in a perceived danger. And the action led up to that moment from a toll stop at that time was declared irrelevant because they only considered 2 seconds. Not the 5, not the stop, not the totality, which is why this decision is now one that you can apply. Because I want you to reflect on that. By them looking, by the court at the time, looking only at the narrow instance, if the officer was in actual danger, the shooting was deemed lawful. This also meant that even if the officer's prior actions created it, they wouldn't count. This was the argument that I made in the Tennessee v. Gardner case. Because the officer's actions created the danger that he was afraid of. Always think about that. Because he was not in any actual danger. The vehicle wasn't coming towards him. He was on the side of it. And in this case, he was in the back of it. Now, I want y'all to do me a favor. Hold on, I'm gonna actually have to tell my wife real quick. Hold on. Yes, ma'am. I'm doing well. And you can actually say hi to my viewers because you're on my live show now. That's all right. And I love you back. Bye-bye. Well, I feel loved. Got a call in the middle of the show. I appreciate that. Anyway, when the officer's actions create the issue, it is 100% on the officer, not the person that they were afraid of when someone else creates the danger that they fear. So this is why, moving forward, when the Supreme Court heard arguments, then in May, the court issued a unanimous 9-0 opinion written by Justice Elena Kagan. The court flatly rejected the Fifth Circuit's moment of threat rule. Justice Kagan emphasized that every use of force case must use Graham v. Connor framework, requiring Careful attention to the facts and circumstances of each particular case. Graham v. Connor is the case that deals with what excessive and what actual force is allowed and even perceived, which is what I used in the application for the Tennessee v. Gardner case whenever we were speaking about that one. So I want you to understand that. They said the moment means nothing without doing the entire circumstance. Why? I always talk about the weapon they use against us. It's the lack of specificity. Why? Because we can weaponize specificity against them. Now that there are people that are going out and doing just that, holding them liable and being specific, they now are saying, hold on. This is not just a police issue anymore. The totality of circumstances, they can actually hold us liable for not using it. Because I hear people all the time, because even in my comments, especially on TikTok now, I'm actually getting on, TikTok is getting on my nerves. I just want you to know that. Where people are saying, well, they ignored this and they don't do this right. And I had the proof of this. Because here's the thing. When you're saying that, you're only re-edifying the video I did of how not to hire me. How not to have me consult for you. How not to have me guide for you. It's because, one, it's probably not written correctly. Two, you don't know how to enforce the document that you have proof of. And three, just like someone said, oh, we're going to get an affidavit and I'm going to do this. They ignored my affidavit. That's because you don't even know what the affidavit is or how to use it. And it's like any game. It's just like chess. Every piece has a certain movement it can do. Most people have they got the board that looks real pretty. They see all the squares on it, and they got all these little pieces. And they just put them down, and they have no idea how any piece works. Now, well, I know they go forward, but do you know what piece goes what way? Because each piece moves distinctively. Each piece has a certain significance and power. Each piece has a certain plan and usage. If you don't know how to take these things apart, because even when you're using it as a strategic plan against something or someone, you still must go in with your eyes open and know how to play those pieces to be most effective for you. Because you may not need all your pawns on this one, but you do need 3 of them: a knight, a bishop, and your queen. Some you might have to use every piece you have. Some you may only do it in 2 or 3 moves. But again, that strategy depends on how you are effectively understanding and applying the game. And most people have no idea how to play the game. And that's why when they have all these things, they don't know how to do them or how to apply them. And even in this case, I was apparently future speaking, because the case that they were using was the exact same application that I was applying. Why? Because law is not ambiguous. Law only cares about itself. But it's pieces. Each one of those pieces, because actually I want to say I used a case a couple of days ago in which a person told me, he said, I've been watching you for 4 or 5 years and I saw that case and I've never understood that. And you used that case with something else and it made perfect sense because, again, that case is a pawn. I used it with a knight. I used it with a bishop because small does not mean ineffective. It means using it strategically to be as effective as I need it to be. And just like going through this is understanding how to build on every case that you're doing. Because let's take the totality of the moment. Or actually, let's do this. Let's take totality over the moment, because that's what Barnes v. Felix does. The original application, because matter of fact, let me give you one more story before I keep going on, because I spoke about this a couple days ago. There was a young man. He was naughty. He was using, he defending himself. Well, I told him use this argument. Didn't use it. He is now in the state Supreme Court, and he's using the original argument. Now, do you know what the problem is? The state Supreme Court is saying, hey, you didn't use that argument to begin with. So now you have to stand on something else. Now, not because he didn't use a good argument, he didn't use the argument that fit his situation. So now he can't bring up the most effective argument for him, which is why he's in the Supreme Court. And even in the context of that, he may feel cheated if they don't rule in his favor. Why? Because he does have grounds. The problem is he had the wrong argument. He has a valid one, it's just not the right one for his situation. And these are the things that most people do. They're going through and they're making arguments where there are none, and they're leaving the most effective one to be ineffective for them. Because even when we're talking about this, again, future speaking, I used what law was available to me at the time. Now, the application of it was what makes it difficult. Because holding that the Fourth Amendment reasonableness inquiry could not be sliced up at the time. Because most people didn't argue it the way I was teaching it. Because they'll argue a blanket Fourth Amendment violation when in fact it's one piece. Most people don't argue Terry v. Ohio the way I argue Terry v. Ohio, because I argue it sectionally. Which is why whenever I spoke about the show of authority stop and it coming from Terry v. Ohio, most people never had paid attention to it. Why? Because they argue Terry v. Ohio just for the search, not for the things that lead up to the search. The empty commands with no crime. Understanding that a traffic citation does not equate to a crime. Why? Allen v. Wright. Because Allen v. Wright gives you the standard for standing. Wren v. U.S. does not call a traffic infraction a crime because it doesn't meet the qualifications of standing of an injured party. No one argues those the way I set them up because no one understands this or looks at this the way I do. And this is why when we get to these types of sections, again, apparently future reading this, because most people want to talk to me in the midst of me doing live shows, which, you know, it's also a problem I'm having because where we at? Boom, there we go. Got the 12, 16, and I'm actually doing this show on the 17 Pro Max. You shouldn't have 3 phones. You really should not be doing that. Everybody wants to talk to me right now. Anyway, going through and understanding this. Justice Kagan even quoted the United States government brief to make a point. Split-second facts cannot be hermetically sealed off from the context in which they arose. In simpler terms, you cannot pretend the final confrontation between a vacuum, you can't pretend the final confrontation happened in a vacuum. Because again, what do we learn in 5th grade science? Cause and effect. For every action, there's an equal and opposite reaction. We generally blame the victim, not the one who created it. We overlook the cause to blame the victim. The cause was him jumping on the car, not him driving off. Always understand that. In law, there's a distinction between legal police action and illegal police action. It's called the Constitution and understanding segments and being able to apply them in totality. And this is what Barnes v. Felix does. Because understanding the ruling instructs if an officer made a decision, decision, officer discretion, remember that? Decision, or committed an error earlier, the decision may be part of evaluating the later force. Why? Because a legal action cannot be preceded by an illegal one. I'm going to say that one more time. Because again, go back and watch my videos from the very beginning. I've always said this. An illegal action by an officer cannot be followed by a legal one. But again, apparently I was future arguing because most of these did not apply in the way that I was applying them. Now, this is why the scope of everything that I'm doing now looks different. The court also affirmed that the ordinary gram factors, the severity of the crime, whether the suspect posed an immediate threat or imminent harm, and whether he was resisting, but said to apply the whole scenario. For example, pulling a gun on someone fleeing a toll violation might look very different if the officer himself provoked the flight. I'm going to say that one more time. Pulling a gun on someone fleeing a toll violation might look very different if the officer himself provoked the flight. What did I say about Georgia? What did I say that there's on the Supreme Court? You are allowed to resist an unlawful arrest. If the detention is not handled properly, it becomes a de facto arrest and becomes illegal. I said this a couple of days ago. The law hasn't changed. In fact, the law that I'm talking about is from the 1890s. Let that sink in. It's over 200 years old. But when we're talking about it, no one wants it applied properly. Because then it goes into questioning the fact that we believe, or we're taught, police officers are good people. They only make good decisions. When in fact, they're wrong 2 out of every 3 times. I'm going to say that one. They make 3 arrests, 2 of them are wrong. Give you another instance. If your child was making 30s in school, you'd have a problem with somebody because your child is not learning properly. But if your school is telling you, hey, 30 is the new 100, maybe you need to change schools because that system isn't working. That's why you challenge it. These are the things that I'm talking about. Because even in their opinion, excuse me, hold on. I went to speeding again. If the officer creates the danger itself was the officer. Because just like Felix jumping onto the car, Felix created the dangerous situation that he was afraid of, automatically making his use of force unreasonable. That question was not necessary to resolve here. Instead, the court simply said courts must at least consider how those officer actions might change the picture. Because even in their opinion, gave the example of Plymouth v. Ricard from 2014. Officers justified a deadly shooting at the end of a car chase by looking at everything the suspect did during the chase. I want you to notice the difference. 2014, with a moment allotted for the officer, they used the totality of the suspect's actions in 2014, but they only used the moment for the officer. Stay focused now. If Plumlee reasonably was right, he should have simply looked at the full chase in Barnes, not just the last 2 seconds. Because they were looking at everything that Plumhoff did, not the last 2 seconds in which he lost his life. Because the Fifth Circuit refused to do that, the Supreme Court vacated its judgment and sent the case back for a fresh look under the totality standard. Now, what does this mean in practice when you're doing the application? For prosecution and defense alike, the Barnes decision changes how excessive force cases will be tried. Now, also understand, where we at? Right here? 9 years later, they are suing in federal court. Past that stupid 2-year statute of limitation, because that's what they did. Because someone else is telling you this because they don't want you to do it. And I'm going to say this too, because I'm going to do another one. I'm going to do a couple of them today, because this one, the thing is starting to irritate me for the most part. When you're performing under fear and the people that you are trying to go after to change are telling you that you can't do something against them, they're protecting their best interest, which is why they're actually doing things to make sure they're stalling you so you don't go looking for anything else. 9 years. So, now if an officer says he shot because he was in fear for his life, that instant, you must also hear about what happened earlier. And also, knowing is half the battle. You know the body camera, you're going to have to do some digging and hunting and fishing for that. Because 76% of all video don't come from police officers. And I'm going to give you another nugget. Did you know the reason why is because the police officer, not the police force, has to release the body camera footage unless they are terminated. Uh-oh. I let the cat out the bag a little bit, because these officers know what they're doing is wrong. Cognitive participation shows guilt. Not turning over that body cam footage, you got to explain that now. This is why I tell you to challenge everything and make sure the person that's you're hiring is on your team. And if it's a criminal defense attorney, piranha don't eat piranha unless you're feeding them. You got to be shelling out $50K or better for them to be on your team. So understand that. Now, so whenever you're doing this, you use Barnes v. Felix as a powerful tool. Because in the case where you're having to deal with an altercation with police, Barnes allows you to bring in the backstory. It allows you to bring in the totality of circumstances. You can contextualize police testimony. Why? Because this is character evidence. If an officer claims the suspect was reaching for a weapon at the moment, you can ask about everything before. Did the suspect have a weapon that was visible? And hell, you can. I actually in trial I did this a lot because I don't want them looking at me as a suspect. And that's the terminology they're going to use. Did the suspect have a weapon that was visible? Doesn't matter how they answer, because they're going to walk themselves into the lie. Because if there's no video from it, and damn near every state has a video requirement, they got to explain why there's no video of it. And then say, oh, well, we have to take your word. We didn't tie him down. by going to their credibility or their propensity to lie through their reports. Why? Because they don't have the ability to tell the truth because they're using stock language. See how we're using their tactics against them? That is the art of war. You pick up from the enemy and use it against them. People can't argue with themselves. And these are the things that I highlight more often than not. Because you can go and single out the officer's actions. Even if you're arguing self-defense or response to police aggression. Because drawing a gun or climbing on a car creates a peril. And even if you're doing the instigating to where you're arguing, because again, not a crime, and the officer then proceeds to do something that they are not allowed to do, you are allowed to resist it. In that resisting, understand, you're putting yourself in a horrible format in the place to do that, but you still have recourse from it. And I tell people this all the time. I don't care about the rest of that. Give me the story. Let me do what I need to do. And I'll put you where you need to be at. Because even training and policy, they're not trained to do the job properly. They're trained, even requested to break the law to create quotas. Why? Because they're being funded for numbers. They're being incentivized to fill private prisons. Because even casting reasonable doubt, that's using all of their arrests against them, not just yours. Because even in the Philando Castile case, I spoke about how you have a young man who told an officer he had a gun. He told the officer he had a permit, and he complied with orders. He was still shot and killed. Understand, these are things in which Andrew Scott in Mississippi in 2021 involved police breaking into the wrong house at night. Mr. Scott, startled and legally armed, grabbed his gun. Police claimed Scott threatened him in his house. They went in the wrong house and killed Andrew Scott, or shot Andrew Scott. And then they said he threatened them even though they weren't lawfully there. See how I'm about to do something? Because again, in order for it to be a lawful act, they have to have a lawful reason to be there. They were in the wrong, in the wrong house. I'm going to say another name, Amir Locke. They said Amir Locke threatened him with a gun. Come to find out, that deputy lied. He had 4 other cases against him. I actually just spoke about it. And you want to know the one thing they keep forgetting to say? They were in the wrong house. They killed a man going in someone's house with a no-knock warrant, the wrong address, and then used a lie to cover up their actions. Always understand, even in the context of this, the best application of Barnes means using it whenever you want the jury and judge to see the whole story. This is how you use the application of Barnes. In a criminal trial where police testimony is central, you attack the police officer with their own issues, their inadequate training, their inadequate mental state, their propensity towards violence. You use them against them. Because even Barnes gives breathing room for defensive narratives. Because these are Barnes is the ultimate self-defense case against police officers. This is the ultimate light now you can use in getting all this information from Giglio. This is the case that you can weaponize to not only make sure you're able to win your case, but it also is the foothold to opening up your federal case 9 years later. For those with the statute of limitations says Hate y'all bastards. Anyway, you can use Barnes to set that up. And as we wrap up today, let's remember the big picture. Barnes v. Felix is more than a traffic stop story. It's the new rule book for the Fourth Amendment. The Supreme Court unanimously said, do not focus only on when the gun went off. Justice and juries must consider the entire sequence of events. That matters not only for holding police accountable, but also ensuring that anyone accusing a high-stakes encounter gets a fair review of what actually happened. And even in criminal defense, Barnes is a call to action. Use it to challenge cases where police paint only part of the picture, which is all the time. Argue for evidence showing the full context of any stop. This comes in an actual detailed discovery, which most defense attorneys don't do. Ask the tough questions. Why did the officer take that action? Could things have been handled differently? Those answers are always going to be in the affirmative for you. And a defense strategy shaped by Barnes can highlight when the officer's own choices led to the conflict. The aggressive approach, the demands of doing something, the forceful ideas of applying, even if you do not invoke properly, which most people don't. And it just, I'm befuddled. But historically, the law has recognized limits on deadly force. Again, Tennessee v. Gardner. No shooting a fleeing teen if he's no threat. That's literally Tennessee v. Gardner. No shooting someone fleeing unless they're using something other than the vehicle. That's law. Barnes reinforces those roots in modern law. It reminds us that the Fourth Amendment protects context, not just split-second judgments. And finally, especially when you be busting shots blindly trying to find Jehovah. And finally, this case shows the system works. Albeit slow, but it works when you use it. A mother waited 8 years for the Supreme Court review. She waited 9 years to now start seeing some actual daylight from it for the most part, because the money's not going to make up for her child. However, there are things that money can do that can create legacy for her child. But her persistence means that now every courtroom in America must reckon with Barnes' lessons. Because this is the echo. His name is now attached to law for the rest of history. Hence, Hybel v. Nevada. I've had some of his people reach out to me because I've done the video on it. Because, again, that's his legacy. Having his name continue to be spoken is what most people will appreciate, especially when it's put into the light that it's deservedly put into. And thank you for listening to the Supreme Decisions Legal Minute podcast. And whether you're a lawyer, a student, a concerned citizen, someone that's having an issue, you always have access to great commentary, legal counseling, as well as my email, donations, super chat, and things of that nature. Hold on, let me go through some. Because I don't look at the comments mostly. Okay, yeah, I'm not gonna go through all that. But you always have access to me. And remember, next time, stay safe, stay informed, and remember, justice depends on the full story. And I'll see you guys in about an hour. I am out.